porque me dejas. Bueno, mira, señora, ay señorita, nadie sabía lo que iba a pasar. Solamente fuiste y me dejaste solito en la eternidad. Señora, ay señorita, yo sé que ahora estás lejos de mí. Siempre estoy pensando lo que estás haciendo y si te sientes más feliz. Y si te sientes más feliz, oye. Y espero yo que no te sientas sola y que tu vida está llena de felicidad. Porque deseo que nadie tenga que sentirse ahora mismo como yo, atrapado en la oscuridad, solito en la eternidad, solito en la eternidad, oye. Trompeta. Saxofón con Cristian. Toca. Que no te sientas sola y que tu vida está llena de felicidad, porque deseo que nadie tenga que sentirse ahora mismo como yo, atrapado en la oscuridad y solito en la eternidad. Ay señora, ay señora, vuélvete acá, vuélvete. Ay señora, ya se fue.
Konnichiwa. What up, everybody? I get started in a little bit. Yo, what up, Fran? It's so over. Asraka. His honorable holiness. Thank you so much for the gifted memberships. Mr. Chief Justice, may it please the stream. Yeah, they're wasting our time. And thank you guys very much for the gifted mems, the subs, the follows, all that stuff. It really helps out in a major way. In a super major way. Yo, what up? What up, my glib glops? Big news. Donald Trump has just revealed Thanks again for the memberships, guys. I really appreciate it. And the sub, thank you so much. Sharkbait, ooh-ha-ha. All right, guys, I appreciate the support. I appreciate the support, and I appreciate the patience. Sometimes I loop on stuff. That's just how my mind works. I loop on other things that are not in the grand scheme of it, like the most important things in the world. That's just how my brain works sometimes. What can I say? What can I say except... You're welcome. That's all I can say. But we have some actual big news, and it's unfortunately big bad news. This is big bad news. This is unobjectively... Sorry. Did I just say unobjectively? It is objectively, stands independently. Horrible news. Horrible and big news. Big and horrible news. Okay? Oh, it might. Oh, it might. But if we stay focused, I won't get derailed, all right? If we stay focused, don't get off the path, all right? Don't follow the lights. Don't follow the sirens. They're trying to lead us off the path. The path is safe. It might look a little dark, but the path is safe. Don't get attracted by the sirens' calls. I say it so happily. The reason I say it so happily is you got to be a little bit optimistic. You got to take it on the cheek because ultimately... Here's the white pill. I still believe we're going to win the midterms. And that's what matters. And that's what matters. And we can keep our powder dry on the major gerrymandering efforts for 2028. And oh boy, there, we can do New York and we can do this again in Virginia. And we can win again in the lead up to 2028. Okay? So, the ultimate white pill here is, in terms of results, we are not doomed. We are not doomed. I saw a Hassan tweet. I am doing my annual criticism of Hassan. The one criticism I have of Hassan. I only ever do one criticism where he says, those who make whatever inevitable make violence inevitable, right? Something like that. No, that's a bad thing to say because we can still win and we're going to win. And so don't let this doom pill you. Let it wash over you, understand it, and be ruthless and get ready for the next fight, which is this fight. It's all the same fight. Okay? So we're going to do, this is the plan of action. We're going to review this opinion and the dissent in its entirety. We're going to explain why, because I wasn't really steeped in the issues. We're going to explain why we do or don't think it's preposterous. And then we'll take it from there in terms of next steps. Okay? But ultimately, big picture, Democrats are still well poised to take control of the House, even with the VRA bullshit, even with the Tennessee, Texas, Ohio, all the bullshit, even with what's going on in Florida. Don't expect the Florida Supreme Court to be objective and neutral with their rules. Even with all that bullshit, we can take it. And we should use it to fuel our righteous indignation and anger in the future. So big picture, that should be your roadmap. And we have it. Nothing changes on that perspective, okay? The overall picture has not changed. Look at the approval numbers. Look at the approval numbers for Trump, for Vance, for Rubio, for the economy, for inflation. We are looking at $5 to $6 gas. The American people are not happy with what's happening. And per historical trends and what we're looking at here, we are still in a great position, okay? Don't be blackpilled. On to the more narrow topic of this ruling. Why is this majorly significant? Well, the margin is very, very close. The inches we need are everywhere around us. Okay? So they are, by they I mean Republicans and Democrats, taking every opportunity, some asterisks, to try to get even one seat pickups because the margin is so narrow and we're in such a hyper-partisan time. So going from like a current 6-5 map where Democrats have a plausible 2-seat pickup to a 9-1 map where Democrats plausibly and likely are able to take 9-1, that's a huge difference. If I said 6-5, maybe it's 6-4. I don't know what the current makeup is. It's something. Those are kind of the numbers. That's huge. It's really, really significant. That's the margin of winners. That's the margin right now in Congress, more or less. You know, you swing 4 from Republican into Democrats. That's the House. Okay? So it's majorly, majorly significant. It's the equivalent of the California gerrymander, essentially, with some asterisks. Equivalent, kind of, almost, of the Texas gerrymander. So it was a big equalizing force. And there's another layer to it, which is that the Democratic procedure used here was thought of from a fairness perspective. This is from like a layperson's fairness perspective as like, quote unquote, more legitimate than what the Republicans are doing, right? Now, I actually think we can use that as tackling fuel, all right? You guys know this concept, tackling fuel. I think that we can use that like inherent just desserts, inherent like fairness notion as tackling fuel. But there's that layer to it as well, which is, they did it the right way, not from a strictly legal technical sense, according to the Supreme Court, Virginia Supreme Court now, the state Supreme Court now, but from like a fairness perspective, we would think of like a plebiscite, a general vote, an election as a more legitimate, fair way of resolving major differences than in the middle of the night, changing the rules in some hyperpartisan legislative way after promises not to do that, etc., right? So there's that component to it too. So it looms large over bigger discussions of fundamental fairness, our democracy, and it's very important to the whip count and in terms of Demstrap. Okay? Thank you so much, Common Good. I really appreciate it. Thank you so much for these comments. Your positive comments, guys. I am as the duck. You got to be as the duck. I can take a lot of the negative comments. I can take them. I can take the criticisms. In some ways, when I see the criticisms that are untailored and are kind of not really on the merits, it makes me feel more vindicated on my ultimate positions. So I can take the comments and I can take the negativity. I'll take it for you. I'll take it for you, folks. Don't worry about it. But the positive comments, I let them wash into me. They are my source of inspiration. And so all your positivity, I embrace that, and it actually has a big impact on me when you're able to give those little moments of light. I'm as the duck with the negative, and I'm welcoming of the positive. So I really do embrace and thank you for your positive comments. Okay. On to the weeds of the matter. The weeds of it all. I guess I'll ask you guys any framing questions before we get into the meat and potatoes of the opinion. Any like framing questions, any overall structure questions besides what to do next. Don't ask me that yet. But anything like leading into this that's unclear. This is a state Supreme Court decision. There's almost no chance, I will say there's essentially 0% chance that there's an appeal method to the Supreme Court of the United States. Why is that? Because as a matter of state law, the Supreme Court is the ultimate decider of what the state constitution means under state law. Okay? The federal Supreme Court, the U.S. Supreme Court has not any interpretive say, maybe to the extent that state law contradicts federal law. And in some edge cases, perhaps in correcting interpretations of federal law that could like find themselves embedded in the state law. But those are very rare things. This will be the final say, for now, final asterisk say on the meaning of the state constitution, which is what this opinion kind of is about. All right. So don't expect an additional litigation strat absent some shenanigans that is going to achieve the desired outcome, because this is the ultimate say on state law, and the Supreme Court will just no. I don't even think it's worth appealing to the U.S. Supreme Court. I don't even think that there's a ground to do it. So don't expect being like, well, we're going to the U.S. Supreme Court. That's like some Trump shit, right? He'll do that. He'll appeal anything to the U.S. Supreme Court, and he'll win half the time, even if it's bullshit. Even if it's a pure state interpretive question, the Supreme Court will find some way to get involved. Thank you so much, Josiah. Potter Politics. Everyone follow Potter. Any conservative court in a blue state needs to be packed. Oh, shit. GOP packed their courts in Utah and other states when they got rulings they didn't like. Dems need to get on board. Well, we're going to talk about that, right? We're going to talk about that, of the shenanigans, because unfortunately, there are some limits here. Unfortunately, there's some limits here on what you can do in Virginia in terms of packing. The same kind of provision, or a similar kind of provision, which is the question here for the constitutional amendment, is also there on the size of the court in Virginia Constitution. Okay? But there's still shenanigans you can play, all right? Very famous phrase from CGP Grey when he was reviewing Supreme Court shenanigans. There's a great video. He's not a lawyer, but I thought it was a very great video where he says, shenanigans beget shenanigans. It's controlled via statute. It is and it isn't. The General Assembly needs to propose it 2 times in Virginia, like between sessions. So it's fixed at a minimum of 7. They can increase it up to 11, I think. And they have, but they have to do it in a longer process. It needs to be approved by, like, I think with either 2 sessions or 2 elections or something like that. Oh no, debate board is getting into it. I didn't even read the opinion, wet his pants, and then demands court. Oh no, don't listen to debate board. He's one of our doubters. Doubters in, believers in as well. And guess what, guys? I'm making a new rule for now. New rule. It's controversial, I know. But for the next couple months, we're going to try it out. Weebs are in. Thank you so much for this sub. I really do appreciate the subs and the support, guys. We're going to get into the opinion very shortly. Don't worry. But any questions, any framing questions besides what to do next before we get into it? Pisco needs his own Doom mode. Yeah, I don't know about that. Timothy Douglas says, all I can think about when I see shit going wrong today is all the brain rot leftists arguing in 2016 about the consequences. Yes. None of this would be happening if we just listened to Hillary. Hillary would have saved us. You would like to appeal the decision on Pisco v. Weebs. I'm weary, but I trust your judgment. Could you give context for what the bill was that was struck down? So, all right. This wasn't a bill. It was a proposed amendment to the Virginia Constitution that was approved by the voters. So it was a proposed amendment. And obviously, amending the Constitution contains within it procedures. And the Supreme Court has decided those procedures were not complied with. In other words, you can't just amend the Constitution in any way you want. There are limits on how you can amend the Constitution, right? What numbers you need, when you can do it, how you do it, and different states might have different rules. You know, the U.S. Constitution has its own amendment process, and so they're saying that this referendum is null and void because of the rules regarding constitutional amendments, as you'll see. There is a point of hypocrisy. I know that we're all kind of sick and tired, or maybe some of you are sick and tired on the hypocrisy stuff. Josiah is never sick and tired of the hypocrisy stuff because that's his bread and butter. And you know what? It should be our bread and butters too. I'm not saying it's a wrong thing to do, but sometimes I get bored of it. But it's important to recenter ourselves, even if we are bored. It's important to take the time to talk about the hypocrisy. Here, right? We are seeing the Virginia Supreme Court step in after an election has been conducted, right? To implement and enforce what they construe to be procedural rules and guardrails against the excesses of democracy. In other words, as a restriction on what the public is allowed to vote for, such that they're basically nullifying the entire referendum after the fact, okay? After the fact. Remember all the conservatives saying, you can't throw people off the ballot. That's anti-democracy. That's anti-democracy, right? You can't, even though the Constitution disables certain people who are insurrectionists, who commit insurrection, or who aid and abet the enemies of the Constitution, as understood in Section 3, they say, well, that's anti-democratic to not be able to have someone on the ballot, right? In other words, you can't have constitutional guardrails that limit what you can vote for argument, that was not something they genuinely believe in. And by the way, folks, it's not something that I'm inherently against either. I do think that there should be limits that are in place ex ante, that is before things are done, that restrict how the public is allowed to vote. I don't think that anyone should be eligible to be president of the United States. And I don't think that the amendment process should be the same as the legislative process. I think it should be harder to implement an amendment than... Now, I'm not saying that I agree with the process that Virginia has, but just understand that they never believed, regardless of whether you in principle believe, that there should be limits on democratic excess. And I agree with that because we live in a constitutional republic that has those checks and balances. That's what rights are. Rights are protections in many ways, right? It can be conceived of as protections against the excesses of democracy. Even if the majority wants to do a naughty little First Amendment breaching law, it says Congress shall make no law, right? Abridging the freedom of speech. They can't do it. Even if the majority in Congress wants to do it, they can't do it. But they never believed it. The MAGA people never believed that, put everything to the vote, let the people vote, let the people decide. The people will decide your fate, Inspector Javert kind of thing. They never believed in that stuff when it came to the Section 3 argument. And now it's apparent, right? Because they're all celebrating the annulment, the nullification of a vote that already took place. In the context of Section 3, we're trying to apply it prospectively. And here we're retroactively nullifying an election on procedural guardrails. I clarified what I meant by they, Mr. Debate Bore, Mr. Dumb Boomer. This guy's like a stupid boomer. No, we don't ban just because of disagreement. Oh wait, this guy we do ban. Please ban this person. We don't allow racial things like that. Yeah. Okay. I want you all to see the maps. We have a 6.0 version 2 in Louisiana. You mean of the Republican maps? Yeah, some crazy shit. Some crazy shit. Okay, where are we? Let's get into the actual opinion. You feel me? We got a 4-3 decision authored by Arthur Kelsey. Now, understand that the justices are like officially, quote unquote, independent. I've seen some like whip counts and that like the belief is that it's a slight conservative majority in terms of biases or in terms of like alignment, but I haven't confirmed that. I'm not really steeped in the partisan makeup of the Virginia Supreme Court. That's just what I've seen reported. Thank you for the raid, I guess. Cool, thank you. Cool, thanks for the raid. From the circuit court, this is the trial level court. So if you guys remember, there was a trial court opinion which enjoined, ordered, paused the usage of the newly approved maps. And there was some slight indication that this might have been a bad decision when they refused to stay that order. It wasn't like a total preview. Oh, and then one other thing before we get started. This shows you the limits of realist analysis. It shows you the limits of realist analysis, right? I told you, and I was upfront about a week ago. People were like, hey, we're concerned about this, whatever. I offered a realist analysis, and I said, listen, I don't know anything about these legal issues. I haven't really looked at them. My realist analysis is I usually think it's like unlikely for courts to annul elections previously. They had the opportunity to prevent the election from ever happening. The fact they didn't do it, and the fact that they rely on legislators for their position indicates to me that as a realist, I think it's likely to be upheld. But it shows you, but that was me saying and being honest with you up front. It's not a legal analysis. It's a realist analysis, okay? So it shows you the limits sometimes of realist analysis. Shows you the limits of that analysis. You can't just say, even in the U.S. Supreme Court context, not enough to just say, hey, they just always give Trump wins. That's not how it is. It's not the case, right? The Supreme Court's always just giving Trump wins. That's a flattening way to do it. And I'm going to keep giving you realist analysis, but I'm just going to, like I did when I told you about this decision, I'm going to just flag it as a realist analysis, right? And that its limits should be thought of. That they're not, it's not a full comprehensive view or prediction. You get me? But yeah, if there's a limit to how much you can predict just by knowing the partisan composition. Cool. On March 6, 2026, the General Assembly of Virginia submitted to Virginia voters a proposed constitutional amendment that authorizes partisan gerrymandering of congressional districts in the Commonwealth. We hold that the legislative process employed to advance this proposal violated Article 12, Section 1 of the Virginia Constitution. The constitutional violation incurably taints the resulting referendum vote and nullifies its legal efficacy. Okay? In other words, your attempt to implement the amendment and put it to a vote, there's a incurable procedural defect. From where does that procedural defect arise? From Article 12, Section 1 of the Virginia State Constitution. So it explains a bunch of concepts that are going to be at play. The first is the notion that this defect, right, comes from a state constitutional source. So it's not going to be able to be appealed to the federal Constitution and to the federal Supreme Court. So it's a state issue. The second is that there is some notion that not all, perhaps, violations incurably taint a referendum. So you can expect to see maybe some thought on when and how a defect or a violation, an assumed violation, will or will not be sufficient to be a nullifying and incurable defect. And then ultimately, a reminder of the status quo. Pre-referendum, Virginia was not allowing partisan gerrymandering. Similar to, by the way, Florida. Don't forget that Meatball Ron DeSantis, Ron DeSanctimonious, that's one of my favorite. Trump was cooking with that, with DeSanctimonious. I don't know about you fucking libs, you lefties out there who are constantly whinging, but he was cooking with that one, wouldn't you say? One, if he cooked with DeSanctimonious, and two, if it was dumb. Someone says, I prefer Meatball Ron, to be honest. I prefer Meatball Ron. We got some honest libs in the chat here. One Direful Pot says, it's horrible. I did see the Federal Trade Court whacked the Section 122 tariffs. Yep. I haven't read it, though. We have a 1. We have a 3. Sleepy Joe is funnier. I'm sleeping for Trump. I'm sleeping for Trump. Direful Pot has 2. Okay, all right. Okay, we got a cross section here. He's cooked. This is a digression. So I told you guys that I watched a video of The Quartering by Andy Worski and this other guy. Do you guys know this? You know these guys? And every time that they're like observing Kino Casino, yeah. They'll say, he's cooked! And they'll just say it in that tone of voice, he's this! And I died laughing. It was just like a very funny thing that they did. I probably sound autistic. Okay. Getting started. So on to Section 1 of the Supreme Court of Virginia's opinion. This case comes to us with a historical background. It does not determine the outcome of the legal disputes presently before the court, which are entirely procedural, but it does explain the context in which these disputes have arisen. For the sake of simplicity, we'll collectively refer to the appellants as the Commonwealth and the appellees as the claimants. That's just a way to distinguish terminology here. So the court is starting with history. All right. From Madison's era to the president, this is James Madison, political parties of every stripe have offered, if by whiskey, arguments supporting partisan gerrymandering. Since that time until today, these arguments have been criticized by thoughtful jurists and legal scholars. Partisan gerrymanders, Justice Kagan has observed, deprive citizens of the most fundamental of their constitutional rights, the rights to participate equally in the political process, to join with others to advance political beliefs, and to choose their political representatives. But remember, and this will often happen with Republican jurists, right? They'll pluck quotes from liberal opinions by liberal judges, and map it onto a context to which it does not apply, in my view. Yes, Kagan dissenting and losing, right? And losing in Rucho versus Common Cause. We're in a different world, right? So we have the state Supreme Court of Virginia noting that partisan gerrymandering is a deprivation of fundamental rights in the context of it being approved essentially by the U.S. Supreme Court, and states given license to go however far they want according to the Supreme Court. And in the context in which so strong is the Rucho versus Common Cause decision that it's effectively gutting Section 2 of the Voting Rights Act. That's how different a context we're in. Oh, I was going to talk about Meatball Ron. Sorry, yeah. So Florida is not bound by this kind of precedent, but Florida also has a rule that is supposed to ban partisan gerrymandering. So just keep that in mind. Echoing Justice Kagan's warnings, right? And here, we're not really getting a historical argument as such, right? He's not saying, well, what was Madison's thoughts regarding partisan gerrymandering? He's basically saying partisan gerrymandering sucks, according to, quote, thoughtful jurists and legal scholars. And who is he calling a thoughtful jurist and legal scholar? Justice Kagan, right? Justice Kagan and the libs. Ruth Bader Ginsburg, Breyer, Sotomayor. These are the thoughtful jurists. And so it just, again, I'm not saying that they're disingenuous or whatever, but it is very frustrating to have these decisions being used as fuel against Democrats. And then, oh, you guys were so thoughtful when you were saying the right thing in that context. Echoing Kagan's warnings, Professor A.E. Dick Howard advocated that Virginia should amend its constitution to discourage, if not outright prohibit, partisan gerrymandering by the legislature. Thanks, Dick. Thank you so much, Dick. He trenchantly argued that partisan gerrymandering undermines democracy itself. These views are widely shared by prominent scholars, historians, and political scientists. Now, is this a polemic about whether partisan gerrymandering is good or bad? Or is it a legal opinion, right? Were we asking for a policy argument on partisan gerrymandering? So just note who asked. Many people inveigh against partisan gerrymandering, he observed, while advocating for the constitutional amendment to establish Virginia's Redistricting Commission, but we in Virginia are about to do something about it, citing Mr. Dick Howard. A year after that optimistic prediction, Virginians voted by a wide margin to reform the redistricting process in the Commonwealth in an effort to end partisan gerrymandering. It is my belief, by the way, this is Pisco talking now, that this was naive. That it was a dumb strategic move by Democrats. Democrats sometimes, I think, and this is a kind of criticism, a lib criticism that I understand and I love, actually. Which is that, like, Democrats will sometimes just do things symbolically because they're so angry and offended that actually are futile to their ends. Now, there are some ways in which I think that Democrats should be doing more, but sometimes there is also an impulse to just, like, do something that's not only futile, but it's also counter to your own end, right? So I thought it was always naive to do state-by-state partisan gerrymandering bans in Democratic states. Like, that's just going to lead to the worst of all worlds. Now, Democrats are the only states that have no partisan gerrymandering, and Republicans can go wild. So this is I'm sorry, you could call that a lib critique, the impulse to just do something even if it's futile, or you could call it kind of like a critique of this kind of virtue signaling centrism. Yeah. Sorry. I didn't mean to use that word. I know that's a disputed word. So you can construe that it's kind of a fecklessness argument. It's kind of like a virtue signal argument. Like, why are you guys banning partisan gerrymandering? Is it just a signal that you disagree with Rucho versus Common Cause and because you're impotent to do anything about the Supreme Court decision? It doesn't seem to advance our ends, right? So, yeah, and I certainly understand that. I think that we need to be more ruthless. Yeah, I agree with it's a useless principle. I agree with Jen Wink that we need a nationwide solution. Yeah, totally. I know. I shouldn't have used the word. My bad. So just keep that in mind. Like, why did we do this? This was dumb. They adopted Article 2, Section 6A of the Constitution of Virginia to create the Virginia Redistricting Commission under the 2020 amendment. If this bipartisan commission could not reach a consensus, the responsibility to achieve the amendment's ultimate goal, ridding political partisanship as much as possible from the redistricting task, would become the constitutional responsibility of us. In 2021, partisan disputes in the Virginia Redistricting Commission deadlocked the 16-member commission. When the task fell to us pursuant to Article 2, Section 6A, we, and by the way, love that. Love to have this bipartisan redistricting commission that just deadlocks. Oh, so now what do? We just go to the Virginia Supreme Court. And who's the Virginia Supreme Court made of? Appointees, partisan appointees by the legislature. So that's smart. When the task fell to us pursuant to Article 2, Section 6A, we unanimously ordered the prior district maps be replaced with wholly new maps that commentators across a wide spectrum of political views later deemed to be free of partisan bias. Citing Dick Howard, the court said about its task with great... Is this guy... Let's see what's up with... Let's look at this guy, A.E. Dick Howard. I don't know this man. Someone... A.E. Dick Howard. What's he doing? Does he have a Twitter? I want to tweet at him being like, thanks a lot, dude. All right. The court set about its task with care and with results that whatever critics might have expected were a vast improvement on the old ways of doing redistricting. Virginia got an overall A for its redistricting maps for the U.S. House, the Virginia House of Delegates and Virginia Senate, and the maps provided no partisan advantage. The new maps were, and they were lauded as nonpartisan. Sets up. We understood then, as we do now, that no tenet of free government is more fundamental than fairness in voting and representation. This enduring principle served as the anchoring ideal of Article 2, Section 6A of the Constitution of the Virginia and the ultimate goal of our constitutionally assigned redistricting task. Here's the question that you should ask yourself, right? Why is this relevant? Why is extolling, there's your SAT word of the day, why is extolling the virtues of this independent redistricting commission relevant to the procedural issues in this case? Do you understand why I get like very skeptical and just like, I don't know, conspiratorial when the court does things like this? It sounds like they're trying to make an argument that appeals to people from like a policy perspective, as opposed to getting right to the procedural defects. It either is the case that the amendment process is X and it requires Y, or it isn't. And they were either complied with, fairly construed, or not. And they either should be granted relief or not. Why are we laying out a treatise, or a policy argument on the virtues of the amendment that was previously passed? Do you understand? Like, the voters also decided on another goal, right? And that other goal was to fight back against MAGA redistricting efforts that are unfair in the overall nationwide context. And that has its own virtues, which you're not talking about here. And the truth is, right, this isn't an opportunity for you to write like whatever you want on policy grounds and say, well, we like this amendment better than the new amendment. And so that's why I get suspicious. I'm like, you're not being forthright here. This is not relevant. Why are you trying to insist that the amendment was good, bad, or whatever? On October 31st, 2025, during a disputed special session, two procedural aspects of the special session are challenged in this case. First, the General Assembly in 2024 applied to the governor for a special legislative session. The application said the special session would consider only such matters as are provided for in the procedural resolution for such special session. The procedural resolution did not authorize the General Assembly to propose constitutional amendments and required unanimous consent to consider matters not listed in the procedural resolution. The General Assembly later, on a party line vote, expanded the scope of the special session to authorize legislative proposals to amend the Constitution of Virginia. So, again, kind of front-loading the procedural conclusions, which should be the focus here, in a footnote. The General Assembly approved by party line vote a proposed amendment to the Constitution of Virginia that would temporarily suspend Article 2, Section 6A. In its place, the proposed amendment authorizes the General Assembly to redraw congressional districts outside of the regular decennial census redistricting as a response to other states that also redistrict outside of a decennial census redistricting or court-ordered redistricting. Makes total sense. Makes total fucking sense. The proposed amendment would authorize such redistricting to take effect for the upcoming elections. During the 2026 regular session that began in January, the General Assembly again voted by a party line to approve the proposed amendment, right? So you have the special session, special session 1. Then you have the general 2. Okay, we approved it in 1 and we approved it in 2. Okay, so we've approved it in 2 sessions, in the special and in the general. In February 2026, the General Assembly enacted and published a new map for the congressional districts contingent on approval of the proposed constitutional amendment by a majority of the voters, and upon certification of such results, these new districts replace the existing nonpartisan map with a highly partisan. Always look for this like moral loading. This moral loading. Partisan gerrymandered map represented expected districts divided. Representing expected districts divided 10-1 between the two major political parties. Under the proposed new map, approximately 47% of Virginians that voted for representatives of one of the major political parties would now be represented by 9%. Yeah, this is called partisan gerrymandering. Why note this, right? Why note this? Is this relevant to your analysis in any way? How is this relevant? The General Assembly first submitted the proposed constitutional amendment to Virginia voters on March 6, 2026, the first day of early voting. The submission was accompanied by a ballot asking to answer yes or no to restore fairness in the upcoming congressional elections. 55%. So of all the votes, 45 were cast during the early voting period, 55 on the final day. The Virginia Democrats of Elections Department of Elections, that 1.6 million voters had voted yes. 1.49 million had said no. Okay, those are the results. In a constitutional republic, it is emphatically the province and duty of the judicial department to say what the law is. Chief, whenever you see this, you know you're about to see some bullshit. I'm only joking, but this is often the you might say the axiom of courts when they're about to do some shit. All right. Chief Justice Marshall learned this truth 2 decades earlier from his former law professor, another Virginian named George Wythe. I don't know. Sitting in our seat of judgment in 1782, Judge Wythe laid down the 2 cornerstones of judicial review: the duty to declare the constitutional boundaries of political power and the courage to fearlessly protect them. His admonition was timeless. If the whole legislature, an event to be deprecated, should attempt to overleap the bounds prescribed to them by the people, I, in administering the public justice of the country, will meet the united powers at my seat in this tribunal, and pointing to the Constitution will say to them, here is the limit of your authority, and hither shall you go, but no further. Well, everyone agrees with this, and some people doubt Marbury versus Madison, but most people agree with this. The question is in how you apply it, whether you're correct or not. Consistent with this Virginian tradition, the Judiciary Department has the power, and it is the duty, to pass upon the validity of a constitutional enactment when put in force by legally questionable means. Scott v. James. A constitution, by its very nature, declares under what circumstances and in what manner it shall be amended. So, the amendment process of the Virginia State Constitution itself has rules and is the supreme law of the land, to which all persons, rulers, as well as citizens, must bow in obedience. Kind of like Section 3, which says, even if you want an insurrectionist to take office in the United States, they can't, even if you want it. You have to obey the supreme law of the land, even if the citizens want to go another direction. Kind of like that. It follows that the judiciary has the ultimate authority to determine the validity of the proposal, submission, or ratification of constitutional amendments. Where restrictions are imposed in the Constitution by express language or necessary implication upon the powers of the General Assembly, the restrictions may not be ignored. I have no problem, as a general matter, with these overall statements. This is true, right? This section is true. It's just how you apply them, okay? It is fair to ask whether we could have or should have reviewed the constitutionality of the proposed amendment prior to it being presented to the voters. It's fair to ask? What do you mean by that? Is this another way of saying we should have? It is fair to ask. What do you mean by it's fair to ask? That someone should ask it, right? What else would you mean by that, right? But also something else to note is the gamesmanship. Perhaps the reason you didn't ask was because, you didn't answer, was because you were hoping that it would be voted down. And now you're in a very weird position, majority of the Virginia Supreme Court. Maybe you're in a different, like kind of a weird position because you did have the opportunity and you passed on it. And what explains that? And you don't have an explanation. And so what do you have to say is, well, I guess it's fair to ask, but that's not the question it should ask. Well, what else would it mean other than it's fair to ask? Other than it should be asked? Weasel words. Absolute weasel words. It's fair to ask, but you shouldn't ask it. What, we shouldn't ask fair questions? Throughout this litigation, the Commonwealth has insisted that we cannot lawfully decide this case prior to the referendum. In its motion for a stay in this case, the Commonwealth argued that long-standing Virginia precedent, Scott v. James, was virtually indistinguishable from this case, and that it clearly held the courts cannot interfere to stop any of the proceedings while the permanent law is in the process of being made, and only upon the completion of the proceedings, if the validity of the amendment is assailed on the ground that several provisions of the Constitution have not been complied with, then the courts can pass upon the validity of the argument. That's the Commonwealth's position. How does it, you're saying, well, you can't raise it because you took this position. Does that resolve your duty? What you're doing? What you should have done? See also the motion for administrative stay and vacatur. The Supreme Court of Virginia especially cautioned that courts may not arrest or interfere with the process of legislation. The court could not enjoin the General Assembly's transmission of a bill to the governor for his or her veto or signature. A judicial injunction of the proceeding is necessary to enact a constitutional amendment would manifestly be an unwarranted interference by the courts with the constitutional process of the legislative department. So to here, well, do you agree or do you not agree, right? This is what I think is like, be clear, right? Do you agree with this or not? You're quoting and you're saying, well, Commonwealth equals hypocrite. Commonwealth equals hypocrite, even though I don't think that you're making a good case for yourself. The Commonwealth concluded that the lesson is clear. Courts may not preemptively invalidate a proposed constitutional amendment before it has been passed. Having successfully insisted over the objections of the claimants that we postpone judicial review of the constitutional amendment until after the election process, because the Dems' fault, they delayed First Amendment passage to protect Spanberger's governor's campaign instead of moving in summer when it would have been legally bulletproof, self-inflicted, unforced error. I like, this is another reason, because I don't think that this is a bad argument, right? What Edward is saying here. Democrats are so fucking scared all the time that they're going to, like, instead of taking the based position early, right? Early. And I don't know if this is a proper representation of what occurred, because I don't remember exactly. But if this is true, it shows that Democrats are, like, sometimes just so, they're too cagey, right? They're too, in my opinion. And that's not to put blame on Spanberger or whatever. She ultimately did it. Maybe she decided she didn't want to. I don't remember exactly. I remember there being some conversation about it, but I don't remember what the internal talks were. So I'm glad that they try to do something, right? But yeah, that's why I think that Democrats should now come out in favor of ripping up the filibuster. Should now come out in favor of court reform. Let the ink dry on their positions. Make it known. Make the argument. Having successfully insisted over the objections of the claimants that we postpone judicial review of the constitutional amendment until after the election process, it might be tempting for the Commonwealth to think that the final vote implicitly stacks the deck in its favor, perhaps enough so that the exercise of any judicial review could be viewed as an ultra-virus effort to overturn the will of the people. If this supposition were true, that Scott forbids pre-election challenges and the will of the people forbids post-election challenges, then judicial review of an allegedly unconstitutional procedures used to adopt the constitutional amendment would not exist in the Commonwealth of Virginia. Here's what I think is like a good solution to this. Don't interfere with legislative processes in the legislature, But if it's something's going to be put up to the vote, there's enough of a reliance interest for people and that we want to resolve those first. I don't know why there ought be parity between how we treat internal deliberative processes in the legislative branch versus sort of questions posed to the people. You can just treat those differently, regardless of the Commonwealth's position. Maybe they're being hypocritical. Claimants assert in a companion case from the same circuit that Scott could be distinguished and that we should issue our ruling before the parties and the citizens engaged in the time, expense, and effort associated with statewide referendum vote. Given the sui generis nature of that case, we ruled in favor of the Commonwealth because Scott was not distinguishable. So, are you saying here that you agree with the Commonwealth? We respect and accept the representation of the Commonwealth Council that no such assertion can be made. An oral argument in this case, the court asked the Commonwealth's Council, I don't understand that as a legal argument, given that you asked us to invoke, ironically enough, named Scott decision from over 100 years ago that specifically says you don't deal with potential procedural irregularities before the people have voted. So saying that the people have voted yes, after having said you don't even look as to whether there is a procedural irregularity until after they voted, doesn't add anything to the equation, does it? Council responded no, and to be perfectly clear, we're not arguing this court lacks jurisdiction to review whether the constitutional requirements of Article 12 should have been complied with. It does. Instead, I'm arguing that on the merits, this court should not have accepted the challenger's arguments. The court again asked, but the fact that there is a yes vote doesn't tell us anything about those merits. No, it does not. I think that's true. On the merits. But the question is just like, A, where do you lie? Do you agree with the Commonwealth? And once again, just like the previous sections about giving the policy arguments in favor of the original bipartisan commission doing redistricting, just like that seems like it's aimed at justifying maintaining the amendment as opposed to the new one, the old amendment compared to the new one. This seems to be trying to be like, guys, we're not upsetting the will of the people. And look, Commonwealth agreed with us. So it seems like very conscious of how this will almost certainly be interpreted by any observer. On the issues before us in this case, we hold that the ultimate vote margin plays no role in the analytics of our judicial review of the constitutionality of the pre-election constitutional amendment process. Neither a high margin of success nor a single-digit margin logically or legally matters. As we earlier explained, it cannot be overstated that Scott focused only on the timing of the exercise of the injunctive remedies, not on a court's constitutional power of judicial review. To be sure, Scott emphasized that the Judiciary Department has the power and the duty to pass upon the validity of a constitutional enactment when put in force. If the electorate rejects the proposed amendment, any pending legal process will be dismissed as moot. If they approve the process, then we must exercise our constitutional duty to review lower courts' declaratory judgments before us on an appeal and address de novo what equitable remedies, if any, are appropriate. So this entire section was about why they're allowed to look at the case now and why it's not a problem that they pass on it previously. And the answer is they have this precedent in Virginia of Scott. This is a Virginia-specific precedent. Article 12, Section 1 of the Constitution of Virginia mandates a detailed, so this is the actual now substantive issue. What is the merits issue that we're even talking about? We haven't talked about it yet, right? So this is the actual Supreme Court going to the merits of what we're all here to talk about. So it has nothing to do with the legality of the maps per se. So this has to do with how the amendment was passed. So what the court is saying, and let's just review real quick. Section 1 was a glaze fest about why we have a redistricting commission that's bipartisan, all right? Has really nothing to do with the legal merits of the case. It was just them spending time glazing, and then they gave a little bit of like a factual rundown of the amendment that was proposed most recently. So that's Section 1. Section 2 starts with general principles of judicial review. That's Section A, right? So we're not at the merits yet. Then we have subsection B, and this is like informing the reader why it's okay for them to review after an amendment after it's been adopted by the people, right? After it's been approved in a vote. So A is about general principles on judicial review. B is about why it's okay as a matter of law to rule on the constitutionality of an amendment after it's been approved. And now we're finally at the procedural substance that is informing why the court rules in favor of Republicans over Democrats. All right. That was all set up to say, here's what we can do, here's when we can do it, and here's why we're doing it now. So that's what we're getting to the why now. All right. So you haven't missed anything. The procedural requirements, that is, of the amendment process itself, right? The amendment process is contained in the Virginia State Supreme Court Constitution, the Virginia State Constitution, and that amendment process itself has requirements. They may seem laborious to some, perhaps even painstakingly so. The ambition of a constitution, James Madison said, is to create a government for perpetuity, grounded by permanent principles and not on those of a temporary nature. Debate, and this is the citation. So Madison said, hey, we're trying to make a constitution that lasts. For this reason, amending the Constitution necessitates compliance with the requirements of a deliberately lengthy, precise, and balanced procedure. He's saying, like, these seem like it's really hard to do an amendment, but that's intentional because we want to prevent the radical changes being done so quickly. Strict compliance with the mandatory provisions is required in order that all proposed constitutional amendments receive deliberate consideration and careful scrutiny. The opening section of Article 12, Section 1, right? This is the amendment provision, right? It's not the redistricting provision. It's not the new proposed amendment. It's the constitutional provision about amendments. States that the first requirement for non-convention methods, right? So there's a convention method of amending, and there's non-convention methods. They didn't have a convention, so the method they use here was a non-convention method, right? So, and the U.S. Constitution also has a convention method and a non-convention method of amending. So there's two ways you can effectuate an amendment in these different contexts. In pertinent part, it provides, that is the Virginia State Constitution, any amendment or amendments to this Constitution may be proposed in the Senate or House of Delegates, and if the same shall be agreed to by a majority of the members elected to each of the two houses, such proposed amendment or amendments shall be referred to the General Assembly at its first regular session held after the next general election of members of the House of Delegates. So the question is, query, did this occur? Was there a proposal in the Senate or House of Delegates to an amendment to the Constitution, which was approved by a majority of the members? And was that referred to the General Assembly at its first regular session after a general election? Well, just on the face of it, isn't the answer yes, of course? The General Assembly passed something in a special session, and then at the first General Assembly session after the election, which was in 2025 for Spanberger, they passed it again. So query whether this was complied with. Was this in fact complied with? Under this provision, the General Assembly can propose amendments but cannot adopt them. The inverse is also true. Virginia voters can adopt or reject amendments, but they cannot propose them, right? And totally agree with that. That's all fine. This constitutional amendment process of dividing power between the people and their politicians have withstood the test of time for more than 100 years. It has remained so since the case Coleman. So, and that's also the case in U.S. Constitution. It's not people versus legislature. It's states versus legislature, right? In the non-convention method in the federal Constitution, Congress can propose by 2/3 an amendment in each house passed and then send it to the state legislatures to approve. Was this decided on party lines? So they're independent, nonpartisan, allegedly. I don't have a good sense of the partisan makeup of the true partisan makeup here. What I've heard is 4-3 in terms of conservative versus less conservative, but I'm not sure about that. That's all I'm saying. To guard against hasty changes to the Commonwealth's organic law, its statutes, its fundamental law, Article 12, Section 1 also slow walks the constitutional amendment process. The General Assembly must twice vote in favor of a proposed amendment at two separate legislative sessions with an intervening election at the House of Delegates. That kind of presupposes it, right? So, is this shall be referred to the General Assembly at its first session held after the next general election of members of the House of Delegates. Does that mean, in other words, that you need to pass an amendment before the election and then pass it again at the first session? Or can you have an election, pass it in a special session, and then wait for the first general election assembly? In other words, by just the text of the amendment. Why is it the case? Why it doesn't say the first session, it says the first regular session. If it said the first session, maybe I agree with that then. Then I would agree with this. But it doesn't say that. It says the first regular session. So why couldn't there be a special session at X after an election and then the regular session at Y? You understand that? Does it render regular surplusage here redundant? If this says first session, all right, I hear you. You only had one session. This was the first session. And so you can't have this until the next election. But it says first regular session. So I'm just telling you, when it comes, and this is a kind of technicality thing I'm raising, but I think that you need to be highly technical when you're dealing with this kind of constitutional language. That we should read in that each of these words matters. These are lawyers who are drafting these constitutions. You get me? You're saying the X in your example must be prior to, that's the assumption, right? But what if X? So understand X to be the special. Understand Y to be regular. All right. I understand if you have Y, where the first time that you propose the amendment is Y, you need to wait until the next election before you have another Y. Okay? And I think everyone kind of assumes that this would be okay. X, E, Y. All right? And everyone agrees that this is not okay, right? So that's not okay. But why is this not okay? You get me? Why is that not okay under the ruling? Under the terms here. You understand this? So everyone agrees with this. That's like the standard. You almost certainly agree with this too. Everyone disagrees with this. Why is this not okay? You get me? I get you. This gives voters two opportunities, one indirect, the other direct, to voice their views on the proposed amendment. The first is during the intervening election period between two legislative sessions. Again, we're just describing a kind of purposivism. The purpose of this amendment was to have an intervening election between when it's proposed. But should we start with the purpose? Don't we start with the text as originalists? Aren't we all originalists now? Don't we start with the text? Is that what the text says? Yeah, I understand after the next general election, perhaps next here is referring to any time it's agreed to by a majority of members elected to each of the two houses. But you could also say the next is reference to at its first regular session held after the next general election. That it's reference to the after is a temporal reference to the election and the regular session. That this component, that is to say that after, is with reference to identifying which regular session it unlocks in, right? That is one way you could read it. But just understand there's an alternative. If the General Assembly votes voters can support or defeat candidates for the House of Delegates who either endorse or oppose the proposed amendment. If the General Assembly votes against it at the next legislative session, the process ends there. If the General Assembly votes in favor of the proposal, voters get a second direct opportunity to vote the proposed amendment up or down of the ballot box. The efficacy of the second popular vote depends in part upon the reliability of the first. The reasoning behind this, Delegate Slaughter stated in 1969 during the General Assembly's debates over the later 1971 amendments to the Virginia Constitution, is that constitutions should not be changed lightly. Not only would there be an intervening House of Delegates election where you might be able to get the sentiment of the people on an amendment that you have acted upon previously, but upon reflection, the General Assembly might decide not to submit the amendment. In this case, voting in the general election for the House of Delegates began on September 19, 2025, and ended on Election Day, November 4th, 2025. The General Assembly voted for the first time to propose the amendment to the electorate on October 31st. So here we have, I'm sorry, right? On this account, and I didn't even remember this timeline, it is indisputable that the special session, right, occurred before the election, right? Or are they saying the election was already ongoing? And because it was ongoing, it wasn't before? It wasn't over, though, right? Didn't we just have the Supreme Court say that election day must all happen on one day? The election happened. You vote in advance, but the election occurs on a day, right? That's when the election happens. It's election day, right? Isn't that all what the conservatives have been saying? So yes, you're submitting your votes in advance of when the election is held, right? When was the election held in Virginia? Well, the election was held, election day, not days, right? Election day was held on November 4th, 2025. That's when election day happened, regardless of when the votes were sent and when we count them. Those are different questions about when the election occurred, right? So on that view, like, it just seems trivial that the session occurred before the election. The election occurred on November 4th. Does that make sense, folks? If you were to ask someone when the election took place, when was the November election for governor? Would you say between September 19th and November 4th? No, you wouldn't say that. That doesn't make sense. No. I'm. Does my logic make sense? Right? That the election occurs on a given day. When you vote prior, what are you doing? Right? The election is still occurring on that day. You're just setting your vote in advance. You're just setting your vote in advance to be determined and to be deliberated on that day. Now, there could be counting that happens after. There could be counting that happens before. But when the election happens, right? The election happened on that day. Right? Voting took place on this day. Yeah, you voted on that day. You counted on this day. The election was held on this day. Right? So so you have in October special session. In November, you have the election, which takes place, and then after you have the General Assembly first regular session. I'm like, and I'm being just real here. If I thought that this was the correct decision by the Virginia Supreme Court, I would say so. I would tell you if I thought that they were like correct in the law or whatever. I'm just not convinced on their reading, right? On their reading, election starts on the first day of voting. That's when the election starts. And now I understand how some of the commentary is saying, well, this can affect many other laws, if that's your interpretation. Because if other laws refer to election day, or when the election starts, or when is the election, then that's going to be indexed to whenever voting starts. And if whenever voting starts is a function of statutory law, then you can change when the election. Do you understand the problem? Then maybe other things that are referent to when that occurs are going to hinge on a larger scope. And I think just from a public meaning, right? The public meaning. If you were to ask someone, hey, did this session happen before the election or after the election? Just as an original public matter perspective, would the public understand the special session to have occurred before the election or after the election? And I don't think that there's a good argument from an original public meaning perspective that if you were to, hang on a second. Well, I can't do this right now. My bad. If you were to ask the public what they understood, right, is that this special session happened before the election. The first session proposing happened during the election, right? So that's what we're trying to show, right? This is circular, J bar T. Why is it circular? We are trying to decipher the meaning, right? The whole question is, how do we understand when the election took place? You're saying it happened during is assuming the thing that we're questioning. And I'm offering you and saying, well, as an interpretive strategy, one thing that we are told by our conservative jurists, and that has become almost a de facto judicial philosophy, is originalism. Originalism. And specifically, original public meaning-ism. So to decipher what is meant by when an election starts, you look at the original public meaning of the words of the text. And so at the time that this was enacted, and you were to ask someone, hey, do you think that in this kind of thing, in this kind of amendment procedure, that if a special session were to happen before election day, would that be before the election? And I think that the answer would be almost certainly yes. They would understand that. And you're saying, well, no, it occurred during it. That's just begging the question. This is begging the question, right? Elections occur when the first ballot is cast and ends when the election is concluded by time or final ballot. That's begging the question. You understand why it's begging the question? That's the conclusion. This is the conclusion. What you just offered is the conclusion. What you're saying right there, that's what we're wondering about, is what justifies that. So you need to provide a justification for that. In other words, in virtue of what is that the right interpretation? Exactly. You're summarizing the outcome, not explaining the cause. You're just saying that that's the conclusion. Why is that the case? Right. So you have a conclusion about how to read something, how to understand the meaning of something. And what I'm pointing to by J bar T, that's a conclusion. Now, you can say that's an unjustified conclusion, but no one doubts it. This is a claim. Elections occur when this happens. And the question is, why? In virtue of what is that the result? Okay, it's a procedural fact which requires an explanation and justification. Why is that the correct interpretation? It's a conclusion. Now, one could say it's the best reading. It's not definite. So you could offer in virtue of the definition of when an election takes place. You could say, in virtue of its definition, the definition of an election, therefore, what you just said is the conclusion. That would be something where I would say, okay, that's the justification. Where is that definition, right? J bar T? You need to point to that. Something else you could say, it's the best reading because it's according to the judicial philosophy. We think it tracks the original public meaning of what an election is. Right, exactly. Where does that definition come from? Do you arrive at it through some kind of thing that the Constitution says? And election shall be defined as when the election takes place that day, or election shall be defined in terms of temporality from when it starts to when it ends, the voting specifically. So you could point to a contained definition within the Constitution. You could point to per the best original public meaning, therefore this, right? But just restating the conclusion about how to read it isn't convincing. It's not a justification. Yeah, the original public meaning. You could say, so you could put a lot of things can fit into this justification box. You could say, by definition, per the Constitution itself, a plain reading of the Constitution, per the original public meaning of the term, per some other interpretive philosophy. A lot of things could go into that black box to justify that conclusion. But just repeating it isn't, yes, okay, you understand, got it. So that's why it's not enough to just say, well, the election does in fact start on this day and end on that day. That's the whole reason we're here, right? I always get into the weeds. Always, always, always. That's what we do here. We're trying to get to the reality. And then the court addresses it. The court addresses that in wherever we were. The court just says, in this case, voting began and ended on election day. The Commonwealth sees nothing wrong with this sequence because under its interpretation, the term general election only means the last day of the election, otherwise known as election day. Because election day was 4 days after the October 31st vote to propose the amendment, the Commonwealth concludes that there was an intervening election. In other words, under the Commonwealth's view, the 4-day period, which included a weekend, was the intervening period during which the Virginia voters could find out what the proposed amendment actually said, whether their preferred candidate supported or opposed it, and whether they wanted to use their vote to express a view on the subject. This is all like policy stuff. The question isn't, does it fulfill the general purpose? Does it fulfill the general purpose of why they have this procedure requirement? It's what the procedure requires. What the procedure actually requires. And just saying, well, the procedure is further to an end. Well, this is going to prove too much. It's going to prove too much because on that view, why would we think it's sufficient to have a special session the day before voting starts? You get me? So if what you're saying is, under the Commonwealth's view, it's enough to have it during the election, an intervening period, to find out what it is and to see whether they support it. Well, would it be enough to have it 1 day before voting starts? You could say the same thing. That's what I mean by it proves too much. If what you say is, well, any interpretation of this provision needs to be understood as providing a quote, like a satisfactory or sufficient intervening period. What's the limiting principle? What would that actually be? Would it be overall like 1 day, 2 days, 2 weeks? Yeah, we need 1 year. I mean, people don't understand amendments now. Are you guys following what I'm saying here? This view appears to be wholly unprecedented in Virginia's history. Appears to be or is? In the half century, so it's never been done before. Again, another one of these, in my opinion, bad faith arguments on like, well, you've never indicted a former president before. So? It's never happened before. So? Is that a legal argument? As for 1.3 million or so, yeah, that's federal law. Please don't cite to me a federal statute. That can't define what we're talking about here. Don't cite to me a federal statute. As for the 1.3 million or so Virginians in this case who had voted for before October 31st, the Commonwealth concedes that the clear purpose was to provide them an opportunity to elect delegates to participate in the second legislative vote. But early votes squander that opportunity. Thank you so much for the membership. I really do appreciate it. Oh, yeah, but these were revisions after the fact anyway. Yeah. Thank you for the membership. I really appreciate it. Guys, I appreciate your support. It means the world to me. Early voters squander that opportunity, the Commonwealth contends, by accepting the Commonwealth's invitation to cast their votes during the 42-day voting prior to the 4-day period. Under this thesis, early Virginia voters unknowingly forfeited their constitutionally protected opportunity to vote for or against delegates who favor or disfavor amending the Constitution by not anticipating a legislative vote on a constitutional amendment 4 days before the last day of voting. To be sure, under the Commonwealth's logic, the legislative vote could just as well have been 1 day before. Right, but this applies also to your 1 day before voting. So anything that gets passed must be passed before election day. The Commonwealth's position finds no support from the text of Article 12, Section 1 or the historical meaning of the term election. The predecessor of Article 12, Section 1 first appears in the 1870 Constitution of Virginia. That Constitution sets forth a 3-month publication requirement prior to an intervening election that also used the expression time of making such choice to describe the next general election. But this language, right? This language is not present in the amendment. Oh my God. This feels like an argument in favor of the Democrats. If there was a provision that set forth a specific publication time requirement, and that language or requirement is absent, right? The 1971 removed the pre-publication requirement. Why would we read that in here? We struck out any reference to publication because some of the questions about what sort of publication might be required. Oh no. And now we're doing this legislative history stuff and it's all about the general purpose. And so he's legislating from the bench. So we're not going to read into the fact that they removed a publication requirement. So they removed a language on a pre-publication requirement. And now you're suggesting that that's still there. Thus leaving only the phrase next general election to reference the intervening election requirement, which is not helping you because what you're doing is you're essentially reading in some additional pre-publication requirement. Not one of these expressions since the constitutional amendment provision was first included limited the definition of election to a single day. You're burden shifting though, right? Aren't you burden shifting? In other words, and I think that removing the pre-publication requirement does sort of analytically suggest a distinction between when something occurs and when you have enough notice on a pre-publication on a pre-election basis of the thing occurring. Oh, I hate this. Before evaluating the exegesis of the term election by legal scholars and courts, it is worth observing that the Commonwealth's view would be unrecognizable to the average citizen. I disagree wholly. That perspective should not be scorned but praised. As we have repeatedly said, the words of the Constitution are to be understood in the sense in which they are popularly employed. This is original public meaning, right? Understood by the voters. Totally imagine. With that perspective, imagine one of the over 1 million Virginians who had voted in person before Election Day. The voter says to the officer of the election, "I'm here to vote in the election." The officer of the election responds, "We are not conducting an election here." "But that's why I'm here," the voter replies. "Maybe so, but let me explain. You can vote in the election, but we are not conducting an election today." This is the stupidest hypothetical ever. This is the most slanted hypothetical I've ever seen. This is stupid and twisted. It's pre-election voting. It would make sense, yeah. The election isn't today, but we're letting you vote today. This is pre-election voting. That would be insanely comprehensible to the average person. Yeah, the election's in 2 weeks. Here, you can vote right now. Oh my God. No, I really disagree with that. This is dumb. This is bupkis. Well, it is Virginia. No, people understand the concept of voting before an election. Legal scholars and courts would have had the same bewildered reaction as the hypothetical average citizen. The definition of election has always been broadly denoted the act of choosing. So if someone asks you, when is the election, right? And it's a devastating hypothetical, in my view. Someone asked the Virginia Supreme Court, "Hey, when's the election?" How would they answer? What are they looking for? Put in the chat. If someone asks you, "Hey, when's the election?" A date certain. The day, yes. or sometimes there's pre-counting, but the day in which the election day is, they wouldn't tell you election day. The election is between September X and this date. This is not bad faith pet. Oh my God, you guys are so stupid. Name the bad faith aspect. It's all general stuff. Oh, he's reading into the. No, this is insanely comprehensible. It's everyone understands what I'm saying. No one doesn't understand what I'm saying. I'm not applying a different standard. It's the same exact standard. This is bad faith. A bad faith hypothetical. You can vote here, but it's not the election. We're not going to do the election. No, that's not the way to determine like when the election happens. You'd be like, okay, when's the election? November 4th is the election. You can submit your ballot early, prior, but it won't count until election day. Right. It won't count. It might be counted, but it won't count. The election hasn't taken place yet, right? And oftentimes there are injunctions that happen before the election. When is the election? Oh, I'm sorry. This is crazy. In my mind, it's crazy. Legal scholars and courts would have the same bewildered reaction as the hypothetical average citizen. The definition of election has always broadly denoted the act of choosing. Most, if not all, law lexicons treat this popular meaning as the technical definition of the word, the process of selecting. The term in its most usual acceptance signifies the choice which several persons make. Election is the act of selecting. But we're trying to understand, though, is election in the context of when it takes place, not just that it is an act of choosing. Yeah, then it's going to be a very broad definition. The context that you're looking for is a notion of election indexed to temporality. And what is the average notion then? Right? That's what you need to find out. Not just the general understanding of election, which is, it's a broad act of choosing. The sense of election, it's a kind of equivocation in my mind. The sense of election that you're trying to get a sense of from the people is the whenness of it, the temporality of it. That's the sense in which you want to know the definition of election. The lexical sense of the noun election must be distinguished from the noun phrase election day. The near universal definition of election day is a single day established by law to cast ballots by presenting them in person at a voting precinct. So they're saying the election is this, occurs here, right? And election day occurs on the day. I just think that the normal way in which we understand election in terms of its timiness is like, when is the election? There's just no good answer, right? When someone says, when is the election? You know what they're referring to. They're referring to election day. So yes, there's another term that's more specific and even more clear. But when someone asks you in terms of the time period, when is the election? What they're referring to is when is election day. Pre-election voting. Pre-election voting is occurring before the election. And that's not like an incoherent concept. You can vote before the election. They cast their ballots before the election. Who won the election? I guess that one is more general in terms of who won, but in terms of timeliness, that's the sense in which is most important. Giving both the terms their intended meaning, and again, so he's trying to say that this distinction shows that it's not surplusage and redundant. Black's Law Dictionary correctly observes, in jurisdictions that allow early in-person voting, election day is normally the last day on which voters may cast a ballot in a given election. Okay, but that's not distinguishing when the election occurs, in my view. The semantic differences between these two terms have a rich provenance. Beginning in colonial days, it was common in Virginia and other colonies for elections to last for days as election officials canvassed the countryside to collect votes during elections. In the royal colonies alone was the English system of taking the poll adopted. It called for an oral vote or a show of hands to decide the result. If any candidate or voter demanded it, a poll must be taken, which might last for days. So great was the solitude of the voters' convenience that in Virginia the sheriff appeared at the planter's gate and wrote down his vote without calling him from his plow or tobacco shed. Yeah, where's the term election here? Where's the term election? Did I miss it? I don't see it. Following the English tradition, voting in an early American election continued until all the electors had been heard of. In jurisdictions following this tradition, so by the way, does this mean that the election carries forward until last vote counted? Last vote counted. And again, that can provide problems to other parts of the code which are keyed in on the election. You understand? So reading the election this way as a matter of state law could have cascading effects on other parts of the code, which will result in anomalies to the extent that they're keyed off on elections. Because, and the fact that there are anomalies suggests to you that they don't understand the election date to be this wide temporal region. So that's, look for that in the dissent, because I've seen some legal commentary that suggests that there could be anomalies, but the existence of those anomalies, they're not relevant insofar as the anomalies disprove as a matter of law this reading, but it's just evidence that that's just not how people understand the term. You understand? In other American colonies, eligible voters sent their votes by proxy to prevent the danger and damage that might result from them leaving their land to vote. These proxy votes, the precursor to today's absentee ballots, were written and sealed. Okay, none of this is inconsistent with the reading that the Democrats are providing. In the mid-1800s, it was recognized during congressional debates that the vote in Virginia occurred by voice vote, and it frequently happened that all the votes were not polled in one day, including the most recent election at Richmond and other places. Again, that's all consistent with the reading that is provided by the Democrats. This occurred in the state circumstances. Virginia was mountainous and intersected by large streams. Voters are frequently prevented from attending the polls in one day, consistent with the Democrats' reading. While the events of the mid-1800s led to laws establishing a single day for casting and receiving votes, modern election protocols eventually cycled back to the historical practice of permitting defined time periods. Yes, that's all consistent with election occurring on a day. That's all totally consistent with that. Despite the varying duration of the election process over time, one constant has persisted. From time immemorial, an election to public office has been, in point of substance, no more or no less than the expression by qualified electors of their choice of candidates. When the law speaks of an election, it plainly refers to the combined actions of voters. Yeah, and when does that occur? It hasn't occurred yet, right? The decision hasn't occurred yet. When does the decision occur? When does the final selection occur? When is the point at which you can say, okay, the selection process has occurred? If we index election to the decision point only occurs when the last vote is counted and not before then, if you're going to go by this view, as opposed to what I think is the original public meaning. But if you're going by like, okay, it's the decision, it's the collective decision. The collective decision is being processed. You don't have it yet, right? The combined actions that define the term election, the combined actions, include citizens casting votes from the beginning of the early period and the officers of elections receiving the votes and closing on election day, which in jurisdictions permits early in-person voting. That's the last day on which they can cast ballot. That's consistent. The definition is short and clear. History confirms that election includes both ballot casting and ballot receipt. With this definition in mind, the Commonwealth implicitly concedes that early voting is one of the combined actions of the election when it recognizes that early voting is casting a ballot to be counted on election day. I don't understand how that's an own. Yes, that's consistent with their reading. When governing law authorizes citizens to cast ballots over a period of time, as Virginia does in its early voting, the durational term election and the determinate term election day fit together perfectly. No. You are saying because there's a more specific term, then this term must be more general to encompass the whole time. That I think is fallacious. That's in my view, that is sophistry. I don't agree with that. The metes and bounds of an election begin with the point of casting votes and end with the points of receiving votes and closing the polls on the last day of the election. Election day is the boundary market for the last act constituting an election. So in the period, here's the question, right? When you're a week into early voting, if someone said to you, has the election occurred? What would you say? If someone said, well, it is occurring. Well, that's not the question. Has it occurred? And the answer, I think, is no. At most, you would say it is occurring, but it hasn't occurred. Damn, man. Okay, J Bar T again. This is conclusory, J Bar T. The whole question is what the law says. I don't know why I have to keep calling you out for this. We're trying to determine the best reading of the law. And so for you saying, Peace Code doesn't say I don't agree with the law, that is not what I said. We're questioning what the law says. What is the best meaning of the law? What does the law actually require? Is this the correct understanding of what the law requires? And so it's not convincing to just have conclusions. They cited the law. No, we're all referring to the same thing, right? Don't be stupid. The law is just one piece of text, right? The law is just this part of the Virginia State Constitution. That's the law. So we all agree on what the law says. Now, this law doesn't say, and the election shall be considered to have occurred in this window. It doesn't say that. You'll notice, I know it's hard to read here, but you'll notice it doesn't actually say that. We're trying to Virginia, so that's not the law, right? That's not the law. That might inform our understanding of what the law is, right? I'm not saying that statutes are irrelevant to how you would interpret the original public meaning of the law, but the law at issue, right, is this and only this. And only this. The only thing that we're to interpret is the meaning of this provision. Now, what you're citing, perhaps, that is relevant to understanding what is the best meaning, but it's not the law. All right, hang on. I'll refresh it so you can see it. It's a really, you can't make a shortcut around this. Those statutes statutes might inform how you read it. They don't inform what the Constitution says. Why? Because the statutes are a function of the Constitution, right? Statutes can't define the Constitution. They might be relevant. I'm not saying that they're not relevant evidence, but this is the law, and that law isn't defined by statute. That law just is, right? We're trying to find out the definition of this. And the legislature can't just come around and say, this means just, I don't know, this means toilet after the next toilet is created, right? That would be preposterous. The legislature can't define election to mean that and change the Constitution through a statute. That's the whole point of having this amendment process, is to prevent the legislature from just changing the Constitution. If we were to accept your invitation to absurdity, then all of this could be elided by just passing a statute that changed what the interpretation of words are in the Constitution. Jay Bart, okay, you're really out of your depth here, okay? Why can't statutes change the meaning of the constitutional provision? For the same reason that we're even having procedures that require amending the Constitution and not just letting it be done through legislation. A statutory definition is just legislation, and it hasn't gone through the procedures required to amend the Constitution. So if you say, well, these statutes change what the term election means, you're wrong, right? You have to be wrong, because this was adopted and it needs to be read sort of in light, perhaps it's informative. Perhaps what you're citing is informative, but it doesn't necessarily resolve the case. You still need to conduct a full analysis of this term, and this is the operative law, okay? Not as a matter of constitutional law, no, right? The legislature in Virginia does not have authority and this should be trivial to you, right? Because if that were the case, and what the Virginia legislature did in this case, they would just have defined election differently, and that would have been okay. And tomorrow they could say, we define election to mean tomorrow, and then we're going to ratify it again, have another vote next week, right? We'll just redefine it in the statute. They, of course, can't do that. It's an absurdity. What you're saying is an absurdity. And we'll come down to see what you're actually citing, too, in the opinion. But you're just wrong. What's the constitutional language that you're appealing to? I'm showing this to you. You guys are so fucking brain dead. Please. This is the provision of law. That is the law that we're analyzing and interpreting. You say, show us the constitutional language you're appealing to. That is the language. This language. That's what we're all analyzing here. You're not following, okay? You're not following. Article 12, Section 1. Right here. That's the only thing that we're analyzing to try to understand the meaning of it. Trying to make an end run around that analysis is an exercise in futility. Don't try to do that. And don't make conclusions like, oh, Pisco says ignore the law, ignore the law, ignore the law. That's not what's happening. We're trying to understand what the law says. All right, moving on. We read all this, blah, blah, blah. Okay. And again, I think you pointed to this, these statutes, which Section 2, VA Article 2, Section 3. So why are you suggesting? Yes, no, I've said that the legislation can be helpful to inform the original public meaning. I'm going to get triggered. Ulti Chimera. You heard me say that. You're one guy in me. You literally heard me say that. Article 2, Section 3. Isn't that, let's see. All right, then, okay. It's annoying because I literally just said that. So let's see what you just pointed to. What you said I'm ignoring, right? So something that I haven't analyzed, you're saying I'm ignoring it. As though I'm intentionally being bad faith. And let's look at what you pointed to. And just take it apart again. I think you're out of your depth. In elections by the people, not defined an election, the following safeguards shall be maintained. Voting shall be by ballot, all consistent with the reading of the Democrats. No ballot or list upon any voting machine shall bear any distinguishing mark. That's all consistent with the understanding of the Democrats. In elections other than primary elections, provisions shall be made whereby votes may be cast by persons other than the listed candidates or nominees. Secrecy in casting ballots shall be maintained, except in a provision made for assistance of handicapped voters. Voter votes may be cast in person or by absentee ballot as provided by law. None of this is resolving the issue. Just complete fail on every level. Has nothing to do with at least definitively resolving this case. So I really recommend you just be quiet, all right, and listen. The combined actions definition of election undermines the Commonwealth's argument that Article 4, Section 3's designation of a date certain on which the House of Delegate winners shall be elected should be interpolated into Article 12, Section's definition of a noun phrase, general election. The Commonwealth states that in Article 4, Section 3, the Constitution defines that election as occurring on the Tuesday succeeding the first Monday in November. Section 3, however, never uses the term word election and makes no attempt to define that unmentioned term. But it is, I think it's relevant. Again, I'm not saying this resolves it either. I would agree that this doesn't resolve that issue. But it's some evidence that the fact that the Constitution is specifying a given date, you would understand that a reasonable person, the public, an informed viewer, just reading the Constitution will assume, right? If you're asking when the election takes place, let's flip into Article 4. That's when it takes place. But I agree this is not dispositive. But it's some evidence that of what an original public meaning understanding of the temporality of the election would be. The date certain in Article 4, Section 3, when considered in the context of the provision in the verb shall be elected, describes the time of the final act in the election, right? So at a bare minimum, right, what everyone agrees to is that the special session occurred prior to the final act in the election. The final act in the election. So it would be false to say the election has occurred. I think that's is correct. Because has occurred, right? Like when you say the soccer game happened, the soccer game hasn't happened until the soccer game is over. I think that's the common understanding of events. In legal argot, as well as common speech, a wedding can last for 4 hours, but the bride and groom are not lawfully wed until... Correct. So this is such a beautiful example. I don't know why the court brings this up. The wedding happened. It's after the wedding, right? After the wedding. Well, it's not after the wedding until the wedding happened. Equally so here. Because that's really what we're getting at, right? Is after the next election. So it's not after the wedding until the wedding is fully over. A general election can take place over many days, but it culminates and ends on election day. The successful candidate shall be deemed elected no earlier than election day, the last day of voting in the election. The Commonwealth's contest with this reasoning begins well but ends poorly. As the Commonwealth correctly observes, courts often employ linguistic presumptions. One presumes that the same term used in separate statutes has the same meaning unless context indicates to the contrary. When applicable, this principle raises a rebuttable, not a conclusive presumption. As Chief Justice Marshall explained, blah, blah, blah. What the Commonwealth overlooks in the opposite of presumptive applies when there's a material variation in terms. Citing Scalia's book, Reading Laws, similar but not identical words should be presumed to refer to similar but not identical ideas. The noun phrase general election in Article 12 is not the same verb as shall be elected in Article 4, Section 3. The former textually denotes the cumulative acts of voting, casting votes on election day, receiving those votes. The latter textually denotes a single day. Election day is at the conclusion of which all votes are cast. I mean, I think that this is kind of begging the question a bit too. For those reasons, we hold that the definition of general election in Article 12 describes the combined acts of voting, voters casting ballots and officers of election, receiving those votes and closing the polls on the last day of the election. The plain and ordinary meaning of this expression matches the history. I totally disagree with that. I think this is dog shit. Our colleagues in dissent raise various objections. Some we have already addressed, but a few deserve more specific responses. Several of the dissent's objections were scarcely mentioned by the parties, either in brief. So, okay, who cares? In our view, none of these objections undermine our interpretation. The dissent's lead argument relies on Article 2, Section 4, which empowers the General Assembly to regulate the time, place, and manner and administration of elections and to make any other laws regulating elections not inconsistent with the Constitution. The dissent then points to various statutory provisions sprinkled throughout Title 24.2 and that they argue takes precedence over our interpretation of Article 12, Section 1. The dissent, for example, calls our attention to the Code's definition of general election. A single sentence in the legislator's opening brief on page 32 also mentions the definition. Neither the dissent nor the opening brief, just get to it, holy shit, acknowledge the statute's preamble, which is not operative text. It expressly states the definitions do not apply when the context requires a different meaning. For his part, the Attorney General of Virginia, the Chief Executive Officer of the Department of Law, does not once mention the Code in any of his briefs on appeal, nor did his earlier official advisory opinion issued on behalf of the Commonwealth cite the statute or assert its relevance. Who cares? Okay, the reason why why statutes are relevant, because if the definition of election turns on some component of how the statute defines things, right? If that's the meaning, and that's not what's being advanced here by the majority, then perhaps it would be informative to look, right? If you're interpreting how a legislature defines things to suss out the scope of the constitutional provision, then the statutory information is relevant, absolutely. But it doesn't. That isn't the proposed meaning by the majority here. At any rate, we place little or no interpretive weight on these statutory definitions given their expressly stated inapplicability when context requires a different meaning. A self-limiting statutory definition cannot supersede the literal text of a constitutional provision. This I agree with. That's, again, begging the question. Article 2, Section 4 reinforces this truism by stating that it is authorization to the General Assembly does not contemplate statutory provisions regulating elections in a manner that is inconsistent with the Constitution. I agree with that. The same conclusion applies to the argument that the statute authorizes early voting prior to any election. Again, but this is evidence of the usage, right? This is evidence of the usage of the term and how it's understood. I think it is. Yeah. And so, like, you have to make sense of, like, okay, they were stupid when they wrote this because no one would understand what this means, or they wouldn't understand it. Of course you would understand it. The term general election in the provision appeared in the Constitution of Virginia in 1870. They enacted the code 149 years later. The inferential meaning attributed by the dissent to the modern statute is weak read on which to challenge the settled historic meaning of election. Okay, I don't agree with that. The dissent seeks to bolster its position by relying on Moore versus Pullum. We do too, but for different reasons. Moore held nearly a century ago that the then existing law for absentee voting should be liberally construed in favor of the absent voter, particularly in light of the enlightened and aroused public opinions which seek to encourage and secure the participation of a large number of voters in the exercise, blah, blah, blah. There's additional irony in the dissent's approach. If it were true that the word election in every constitutional context solely meant election day, then Article 2, Section 4's grant of time, place, manner, and conduct and administration authority to the General Assembly to regulate elections would arguably only... No, that doesn't follow at all. Oh my God, that doesn't follow at all. No, it doesn't. You could say that the time, place, and manner of regulating elections also refers to also gives you authority to regulate pre-election voting. That pre-election voting is a way that you regulate elections. So that doesn't follow at all. What a this is just a total fail. I totally disagree with that. If more were written today, we are confident to say that it would say that precluding 1.3 million early votes from having a say in an ongoing debate over a proposed would require a truly illiberal. So now this is purposivism. This is purposivism. Oh, we just don't think that the justices then would countenance this. That's not what your task is. Second, Moore recognized that the Constitution of Virginia can expressly or by necessary implication defeat any contrary interpretation of a statute governing the right to vote. We certainly agree, and none of the code provisions relied upon the dissent can overcome the historic meaning of, all right, just more of the same. The dissent next claims that our interpretation would cause our courts to sit relatively idle for more than 25% of each year. The Commonwealth has never made this rather extreme argument in any of its 20-plus briefs and motions filed. Okay, who cares, right? This is, to me, whenever you bring up that they didn't make this argument, I'm like, okay, so this is a very sensitive point for you. Because our colleagues in dissent sua sponte, by the way, these are all disses. Whenever you see this kind of language, this is like judicial, this is like saying, you didn't even think to make this argument, so we shouldn't consider it. Fuck you. Article 2, Section 9 of the Constitution of Virginia provides in part that no voter during the time of holding any election in which he is entitled to vote shall be compelled to perform military service except in time of war or public danger, nor to attend any court as suitor, juror, or witness. You're fucked then. You're fucked. You guys understand this? Oh my, it's a beautiful point. It's a beautiful point. Who gets this? Oh my God. It's such a defeater. Follow me, right? So we have another part of the Constitution of Virginia. Yes, the entire world stops as soon as the election is on. Yes. That's just a better summary than I could ever say. So the Constitution provides that the world stops when the election is on, right? You don't have to go to jury service. You don't have to go to court. You don't have to go as a witness. It's so fucking stupid. All right. Do you understand that? So this world stopping provision of the Constitution, which says you can't force someone to go to court and be a witness. You can't force someone to do a military service in the Virginia, whatever, militia. You can't do that during an election while we're holding an election. And they're like, okay, so if we say that election takes place when voting starts, then literally you're not allowed to force witnesses for like 25% of an election year. That can't be the best understanding of when an election takes place. It is brain dead. And so debate board says, so you have a problem with the state's constitution? No. Do you think that that's what they did? Do you think that when they did Article 2, Section 9, they're like, so even for early voting periods, it doesn't make sense to force them to go into fucking court. It's an absurdity. We should read these, right? Like we should read the same definition here in Article 2 as 12. We should read those as equivalent. And basically, how are you going to distinguish them? So now during early voting, you can't be sent to, people should try this. Yeah, it's almost like they were using a different definition. Oh my God. This is a chef's kiss. This is such a stupid opinion. We aren't in a war, of course. Of course. But do you guys follow that? You should be pissed. This is bullshit, man. This provision deals with the compulsion that would cause a voter to lose the opportunity to vote. And you can tell that they were very sensitive about it because they're like, no one brought this up. No one makes it's prudent to address it. No one even mentioned this. This provision deals with compulsion that would cause a voter to lose the opportunity to vote. Some might argue this provision only precludes compulsion that would interfere with a voter's one-day access to the polls during the lawful period of election. Under this view, the voter could vote during the election period, and Article 209 would not be implicated. Others might argue, as the dissent speculates, thank you so much, you can drive 120 miles on the highway if there's an election. They literally can't stop you. They can't do anything. Others might argue, as the dissent speculates, that the compulsion is prohibited only on election day, but it doesn't say election day, right? They're so sneaky. It says holding the time of holding an election. And you were very clear before that the time of holding an election is when the first vote starts. That's considered the time of holding an election. So how are you going to get around that? To us, this clever argument is a story of the tail wagging the dog that has no tail. So when you say clever, do you mean like it just totally crushes you? Oh, it's clever. Oh, it's clever. Yeah, election day is the purge. It's a clever argument, meaning it's a defeater. It's a defeater. The textual and contextual meaning of Article 2 was never addressed by the Circuit Court, never mentioned. Of the two arguable interpretations, neither one contradicts our belief. So you don't even decide it, and you're like, whichever, it might be the case that this is the correct. And that's all they say about it. That's all they say about it. Criminal. That's all they have to say about it. They have zero response. Like, it might not be the case, but it might be the case. Anyway, whatever. That's literally what they just did. Some might argue that this provision only precludes it with one-day access, and some might say that it doesn't. Anyway, whatever. Bro, this is crazy. Whatever, the dissent and other stuff. It's an absolutely insane, crushing argument that they don't at all address. It's prudent to address it. How did you address it? I'm using criminal metaphorically. Hey, it's a joke. It's a metaphor. The dissent goes on to suggest that our interpretation also injects unnecessary confusion into the qualifications for state senators and delegates. Oh boy. Article 4, Section 4 of the Constitution requires candidates for these offices to be at the time of the election. Oh no. I just thought of that, right? So when are you of age for purposes of the election? I didn't even think of that. And someone put in the comments a succinct way of describing this. I didn't even think of it's a defeater. It's also a defeater. Yeah, when are you legally 18? These are the anomalies that I referenced at the start of the analysis. If you're 18 before election. Yeah, if you're 18 before the election. Yeah. Age of consent. What are these, libertarians? But Your Honor, she was over 18. No. She was 17 during the election. Because the election is when voting started. So you're just committed fraud. You're under arrest. It's so simple, actually. I'm fucking dead. We do not find it confusing. Article 4, Section 4 provides that any person may be elected who at the time of the election is 21. The time of the election must be viewed in the context of which this, oh my God, may be elected. Hang on. So it needs to be seen in context. Okay, I agree with that. The phrase may be elected has a similar connotation to the phrase shall be elected. And likewise, may be elected refers only to the final act. No shot. No shot. You're saying may be elected at the time of the election, at the time of the election, right? Refers to the final day. It follows that at the time of election means the time when a senator is deemed elected. So time of the election in context of voter or candidate qualification is the final time when you're deemed elected, but the time of the election for purposes of the amendment process is when it starts. Why? That's insane. That's fucking insane. Can you explain it in English? Yeah, sure. Okay. So we have this like notion of when an election occurs for purposes of the amendment process, and when the election occurs for purposes of deciding whether you're qualified to run for office. And when he says when the election occurs for purposes of when you're qualified is the final act, and when the election occurs for purposes of the amendment process, it's the initial act. And they're like, the reason for this difference is, well, context, bro. And that's it. They're just like, well, context. It has a similar connotation to a different phrase. It's not even clear that's a response to me. Like, how is that responsive? I don't even understand. Can you spend more than fucking 2 sentences? See the footnote. We are similarly unconvinced of the context of Article 7, Section 4 supports the dissent's view that our interpretation of election must mean a single day. The dissent posits that Article 7, Section 4 does not state that the county and city officers shall be elected on a specific day, as in Article 4, Section 2 and 3. Rather, it specifies the election shall be held on a single day. The context of the constitutional provision, however, suggests otherwise. Article 7, Section 4 provides for the day when county and city officers shall be deemed elected as the successful candidates in an election. The first paragraph says that there shall be elected by the qualified voters, blah, 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 blah. The second paragraph refers to the first paragraph and it says regular elections for such officers shall be held. The context of this provision suggests a similar purpose and no. So this provision of Virginia law says indexed when they shall be elected to a given day. The dissent posits that amendments does not state the counties shall be elected as in Article 4, Section 2. Rather, it specifies that election shall be held on a single day. The context of the constitutional provision suggests otherwise. Article 7, Section 4 provides for the day when county and city officers shall be deemed elected. Source: the first paragraph begins with there shall be elected by the qualified voters. The second paragraph then refers to the first paragraph with regular elections for such officers. No, but it's the same term. It's elections. The election is held on a day. So how does shall be elected? So now election, because in a previous paragraph, they say shall be elected, that means that regular election means something completely different. How does that fucking follow? The context suggests a similar purpose. Conclusory, bullshit, derivative. Bullshit, derivative. I don't agree with that at all. So this term is different because in a previous paragraph they said shall be elected. But they say regular elections for such officers occur on a day, on a date certain. I don't know why you would read this to modify that elections in this context mean the final act of election. Oh, this sucks. Oh, brother. The Ninth Circuit similarly held that the Supreme Court has provided the device for reconciling the federal election day statute and federal absentee voting statute is the definition of election that treats election day as the consummation of the process rather than any day during which voting takes place. Although voting takes place, perhaps most voting prior to election day, the election is not consummated. Well, we agree with that an election is not consummated before then, before the final day. That's not the question. The question is when is the election? Under Virginia state law. Under Virginia state law. So fuck the Fifth Circuit, fuck the Ninth Circuit, fuck your federal law. We fully acknowledge Ralph. Oh my God. Oh my God. Cringe. Ralph Waldo Emerson's warning that a foolish consistency is the hobgoblin of little minds. As our dissenting colleagues suggest, it truly would be foolish for us to assign by dictate a specific inflexible meaning to the words elected. Oh, so now we're talking about centrist again. So now we're talking about centrist. All right, at least the majority's with me on this. No doubt about that. No doubt. Everyone agrees on that. We are not attempting to do so. You are. You're trying to use election, have your cake and eat it too. That's absolutely what's going on. Yes, context matters, but the context here, I think, is firmly that when we're talking about the time happening of elections, you need to have some basis to believe that the term is going to be understood differently in the amendment process than in the other places. Because it's the same kind of context overall. Now you could say, well, because it's in the amendment process and we want like a real chance or something, but that's just like purposivism. And I don't really think that that's a good argument. We're not attempting to do so. The antidote to Emerson's warning is Scalia's reminder that in textual interpretation, context is everything. Context tells us not to expect nitpicking detail. Oh yeah, don't think about the blatant contradictions and absurdities. Context also includes common sense. To us, it is common sense that the phrase general election, as used in the context of Article 12, Section 1, includes the combined actions of citizens casting. Common sense, cool. It truly would be a foolish consistency if we insisted, and we do not, that the historical definition of election applies in exactly the same way to the plethora of different legal texts ensconced in different policy contexts. The dissent does just that with its inflexible one-size-fits-all definition of election. And that inflexibility ended up denying 1.3 million Virginians the constitutional right to have a voice in that debate. And now they claim the mantle. They claim the mantle of being in favor of Virginians' rights when it comes to elections. Oh, this is scummy. So they're even trying to be sanctimonious and be like, we're the ones respecting the right to vote here. Because the people who were denied the right to vote weren't the people who voted in the referendum. It was the people voting in the general election because they didn't have prior warning about the amendment that's being proposed in a special session of Virginia. What? While the Commonwealth is free by its lights to do the right thing for the right reason, the rule of law requires that it be done in the right way. Affirmed. All right. I think I'm going to give my thought process overall. Shit opinion. I would be happy to actually debate people on this. I think it's dumb. It's already 2:00. It's already 2. Do I have time? Let me check. I don't. Maybe tonight we can finish. I spent too much time getting fucking stun locked. I'm already getting messages. Fuck. All right. I'm sorry. I gotta go. I might be back tonight. No promises. Hopefully we'll do some more debate stuff, but I'll take a read when I'm doing my thing of the dissent. So I might even review it on stream if people want me to do. I can. But I have an opportunity to be active on Twitter too for a little bit as well. So you might see some of my tweets. But I can't stream until like later tonight. Unfortunate. All right. I love you guys very much. Stay cool. It looks like IRI might be live. So go to IRI. Tell them Pisco sent you, and yeah, stay cool. Am I still live? I am, aren't I? You almost got me. You almost got me again. Nice try. Very sneaky.